All right, welcome to this explainer. Today, we're really going to unpack the nuts and bolts of bail, custody, and justice under the Bhartiya Nagarik Suraksha Sanhita, or BNSS for short. We're going to break down exactly how the law tries to balance the massive power of the state against your individual liberty, all using the specific framework laid out in the BNSS. Let's get right into it. So here's our roadmap for today's explainer. 1. The meaning of bail. 2. The custody clock. 3. Default and regular bail. 4. Anticipatory bail and undertrials. And finally, 5. Bonds and sureties. But before we get bogged down in all the technical sections, we absolutely have to ground ourselves with this core philosophy. Bail is the rule and jail is the exception. This profound ruling by Justice Krishna Iyer in the landmark State of Rajasthan v. Balchan case, it is basically the anchor for everything we're about to explore when it comes to personal liberty. It really sets the baseline expectation for how our entire justice system is actually supposed to operate. Okay, Section 1. The meaning of bail, liberty, and delivery. To truly grasp the law, we kind of need to understand the language first. The whole concept actually originates from the French word bailer, which literally translates to deliver or hand over. But what exactly is being delivered here? Well, it's delivering a person to liberty. Like in the famous Gurbakh Singh case, it was defined as setting a person at liberty based on a security. Basically, a promise that they'll show up in court on a specific day. So, at its heart, it's a transaction of trust. Now, there's a really stark contrast in how offenses are categorized under Schedule 1 of the BNSS. For bailable offenses, your release is an absolute right. If you're arrested, you are absolutely entitled to bail, period. But for non-bailable offenses, well, your release is entirely at the judge's discretion. The law literally shifts from an automatic guarantee to a very careful, deliberate judicial evaluation. Moving on to Section 2, the custody clock. Racing against time. So, when the police can't finish an investigation immediately, they can't just hold you indefinitely. There is a strict clock ticking. The police get an initial 24 hours. If they need more time, they have to produce the accused before a magistrate. Now, that magistrate can authorize up to 15 days of either police or judicial custody. But after those first 15 days, only judicial custody is allowed. And this leads right up to a strict non-negotiable maximum detention limit of either 60 or 90 days. The really crucial point here is how that maximum limit is actually decided. It's all about the severity of the alleged crime. If the offense is punishable by death, life imprisonment, or 10 or more years in prison, the state gets the full 90 days. For literally all other offenses, it's 60 days. This is the absolute deadline for the police to wrap up their investigation and file a charge sheet before the whole legal landscape shifts dramatically in favor of the accused. Which brings us to Section 3, default and regular bail, rights and tests. So what actually happens if the police miss that 60 or 90-day deadline? Well, the accused gains what the Supreme Court in the Uday Mohan Acharya case called an absolute, indefeasible right to default or statutory bail. As long as the accused applies for it and is ready to furnish bail, the court must release them. And here's the real kicker. If they avail this right before the charge sheet is filed, it absolutely cannot be defeated. Even if the police rush in, panic, and file the charge sheet 5 minutes later, it doesn't matter. It's a massive, unshakable check against investigative delays. But what about regular bail for non-bailable offenses before that clock runs out? Well, judges don't just guess, right? They rely on this classic triple test. They basically have to balance the accused's right to liberty against the integrity of the ongoing investigation. They ask 3 fundamental questions. 1. Is there a risk of the accused fleeing? 2. Are they likely to tamper with evidence or, say, threaten witnesses? And 3. What is the sheer nature and gravity of the offense itself? Let's actually apply this to the real world to make it perfectly clear. Consider this scenario, the activist's dilemma. Imagine Ramesh, an activist. He gets arrested during a peaceful protest and is charged with unlawful assembly under Section 189. His lawyer immediately applies for bail. So, should the court grant it? The answer here is unequivocally yes, because unlawful assembly is categorized as a bailable offense under Section 478 of the BNSS. Granting Ramesh's liberty isn't some special favor. It is an absolute legal mandate. The court doesn't even need to look at that triple test here, because bail in this specific scenario is quite simply a matter of right. Now let's contrast that with a completely different scenario, the accidental murder case. Let's say Raj accidentally pushes an L during a heated argument, resulting in a tragic fatal fall. Raj has a completely clean record, no criminal history whatsoever, but he's charged with culpable homicide not amounting to murder. Does Raj automatically get bail? In this case, the answer is discretionary. Culpable homicide is a severe, non-bailable offense under Section 480. So here, the judge must apply those triple test factors we talked about. They're going to weigh Raj's clean criminal record against the sheer gravity of the incident. Now, the court will probably grant release, figuring he isn't a danger to society, but they will absolutely anchor it with heavy conditions. Think surrendering his passport or severely limiting his travel, all to completely eliminate any potential flight risk. All right, Section 4, Anticipatory Bail and Under Trials. Section 482 of the BNSS covers anticipatory bail. Basically, if a person genuinely fears they're going to be arrested for a non-bailable offense, they can apply for this preemptive shield from the High Court or Court of Session. Now, it comes with strict strings attached. You must cooperate with interrogation, you absolutely cannot tamper with witnesses, and you'll face travel restrictions. But crucially, and this was confirmed in the landmark Sushila Agarwal case, this protection doesn't just automatically expire after a set time, or even just because a charge sheet gets filed. It can actually continue right up until the end of the trial unless a judge specifically cancels it. But what about the people who don't get bail, the folks stuck in prison just waiting for their trial to finish? To stop our prisons from overflowing with legally innocent people, Section 479 of the BNSS creates a fascinating mathematical safety valve. Listen to this. If you are a first-time offender and you've served 1/3 of the maximum possible sentence for your alleged crime, you must be released on a bond. For normal offenders, it's 1/2 of the sentence. And here's the really important part. It is now the explicit duty of the jail superintendent to actively apply for this bail on the prisoner's behalf. The system itself is legally obligated to get them out. And sitting above this entire fray are the higher courts. Section 483 gives the High Court and Sessions Court these overarching, special powers. They essentially act as the ultimate supervisors of the system. They wield the authority to grant bail to literally anyone in custody, modify the conditions set by a lower magistrate, or, if they deem it necessary, completely overturn a decision and order someone straight back into custody. Finally, let's look at Section 5, Bonds and Sureties, the cost of liberty. Think about this scenario. Let's call it the disappearing act. Imagine a well-respected business person agrees to be the financial surety for a friend. The court sets a really heavy financial bond. A few months later, the accused friend just vanishes into thin air. At the exact same time, the guarantor's business hits financial ruin, and they are facing total bankruptcy. So what happens to the guarantor? Does their sudden financial distress somehow cancel out their obligation to the court? Well, the law is completely unforgiving here. The answer is a hard no. According to the strict rules governing sureties, your personal financial distress does not erase your legal promise. The guarantor remains strictly liable for ensuring the accused attends court. The court can, and very likely will, proceed to forfeit that surety bond. They will force the guarantor to pay up completely regardless of their bankruptcy claims. And keep in mind, while we started this whole explainer by saying bail is the rule, an angry judge will not hesitate for a second to cancel it. But, as we saw in the Gertrude Sin case, cancellation requires what they call supervening circumstances. A court isn't just going to mechanically cancel your bail. They'll do it if the accused actively misuses their freedom, like by tampering with evidence, threatening witnesses, or making a run for it. Remember, liberty is granted on trust. Break that trust, and the privilege is instantly revoked. Which brings us to the end of our analysis. We've gone through the precise timelines, those strict fractions for under trials, and the fairly harsh reality of financial bonds.